Your Honour, if it pleases the Court, my name is Nathan McNeese, Solicitor for QT Lawyers, and I appear before you on behalf of the applicant. Your Honour, there is 106 charges against my client. My client is Aboriginal and 14 years of age, and of course, therefore, a juvenile in the eyes of the law. My arguments are as follows. My first argument is that the evidence which the police obtained at the scene of arrest and subsequently seek to rely on is prejudicial. Firstly, none of the information that was obtained by the police from my client at the scene of arrest was recorded. And further, neither of the police officers took notes. Subsequently, the evidence which the police are seeking to rely on is merely the untrustworthy recollection of their memories of what my client said. It should also be noted, Your Honour, that the police officers did not confer with my client at any point in time whatsoever in order to ensure the validity of these purported statements. My second argument, Your Honour, is that following the arrest of my client, the police drove him around the neighbouring suburbs while the arresting officer and his partner engaged in conversation with my client. The conversation took the form of a series of questions directed at my client to the effect of, did you break into that house there? And what about that one over there? And what about this one? And that one there? And so on and so forth. This question, or questions of this sort, were posed a total of 106 times. It is the answer to these questions which form the entirety of the Crown's case against my client. While my client did answer in the affirmative to all of these questions, it should be noted, Your Honour, that my client's responses were simply a case of gratuitous concurrence, a tendency to respond in the affirmative, notwithstanding the responses were factually incorrect. Gratuitous concurrence has widely been recognised as common amongst the Indigenous. As such, this evidence is prejudicial. This brings me to my third argument, Your Honour. After being questioned on the way to the station, my client was placed in an interview room where he was met by an unfamiliar person whom neither my client nor the defence knew. Presumably, this is who the Crown picked to play a supporting role for my client. After my client had taken a seat in the interview room and before the interview, this unfamiliar person proceeded to advise my client that he should just tell the truth and answer the questions that the police officers ask. At no point, Your Honour, was my client given the opportunity to contact a parent or a guardian. This is the basis of my third argument, that it should have been evident to the police that they were dealing with a juvenile Aboriginal, and it is therefore expected, by virtue of their position, that they should have been cognizant of the statutory requirements that govern the dealings with such defendants. Now, to the legal grounds of my argument. The legislative validity of my arguments is vested in the Police Powers and Responsibilities Act of 2000, as well as the Police Powers and Responsibilities Regulation of 2012. Specifically, Section 240 of the PPRA, which provides that before interviewing an Indigenous suspect, who is a relevant person, the police must inform the relevant person that legal aid will be contacted and allow the person to talk to a support person. As I have already mentioned, none of these requirements were satisfied, Your Honour. What's more, Your Honour, I now refer to Section 421 of the Police Powers and Responsibilities Act, which states, if a police officer wants to question a relevant person and the police officer reasonably suspects the person is a child, they must take the cautions set out in Section 421 subsection 2. Section 421 subsection 2 then goes on to provide that in the instance that the police officer reasonably suspecting the person to be a relevant person and a juvenile, the officer must not question the child unless, before questioning starts, the police officer has, if practicable, allowed the child to speak to a support person, who is chosen by the child in circumstances which the conversation will not be overheard, and a support person is present while the child is being questioned. Your Honour, it is self-evident that my client is an Indigenous juvenile and the police should have identified this. While my client was provided a support person, this person was not chosen by my client. In failing to advise my client that he was free to choose whomever he wished to be a support person, the police officers are clearly in breach of this provision. I must further emphasise, Your Honour, that the support person elected by the police officer was entirely unknown to my client. Furthermore, there is nothing to suggest that the circumstances in question gave rise to an impracticability to follow the rules. As such, the police officers have failed to abide by Queensland law, specifically the cautions maintained in Section 421, subsection 1 of the PPRA. Now, Your Honour, please allow me to refer you to Sections 25 and 26 of the Police Powers and Responsibilities Regulation. Both sections provide for rules of questioning and cautioning that police officers must follow when dealing with Aboriginal people. Section 25, Your Honour, provides that police officers must ask preliminary questions so as to determine the suspect's level of education and understanding. As the facts clearly demonstrate, Your Honour, no such preliminary questions were put to my client. In addition, the police failed to caution my client with the knowledge that he had the right to remain silent, a right which is fundamental to the compliance of Section 26. This failure to comply with the regulations is relevant in determining the admissibility of my client's evidence. The police officer's conduct throughout the interview process demonstrated a blatant disregard for the aforementioned laws, and consequently, the evidence which the police are now seeking to rely on is undoubtedly inadmissible. Please let me conclude my submissions by directing you to Section 5 of the Police Powers Responsibilities Act, which articulates the underlying purpose of the Act. The most relevant provision is subsection E, which provides that the Act was implemented to ensure fairness to and protect the rights of persons against whom police officers exercise powers under this Act. Your Honour, it should be unequivocal from my arguments today that fairness has been conspicuously absent from the police officers' conduct throughout this case. Due to the numerous breaches of the Police Powers and Responsibilities Act, as well as the Police Powers and Responsibilities Regulation by the police officers, Your Honour, I ask you to exercise the Court's inherent discretion, as per Bunnings and Cross, and the case of Ireland, to exclude the record of interview which the officers are seeking to rely on. Thank you. That will be all, Your Honour.